Okay, let's really get into this one. Picture this scene. A seemingly ordinary home, a suburban unit in Victoria. It's late summer, August 2021.
Right.
But for the woman inside, that night, well, it allegedly became anything but ordinary. It apparently spiraled into this horrifying ordeal.
Yeah.
We're talking about allegations of an intruder being held captive for hours, brutal assault, threats, false imprisonment, and even, according to the claims, being choked almost to death.
It's chilling stuff. It sounds like, the plot of a really dark true crime story. And for the person involved, if the allegations are true, the terror must have been unimaginable.
Absolutely. And this alleged ordeal, it wasn't brief. It supposedly started on the evening of August 30th, 2021, and didn't end until the early hours of the next day, August 31st.
That's right. That suburban unit became the alleged setting for roughly 11 hours of violence and control, according to the prosecution's case.
And the key players here, the people at the center of this, as identified in the court documents, well, you have the alleged perpetrator and the resident of the home, the woman supposedly trapped inside.
Exactly. It's the kind of alleged event that leaves profound scars, you'd imagine, both physical and psychological.
But here's where the story takes this really tragic and legally fascinating twist. It shifts from being just about the alleged crime to a major legal battle over evidence rules.
Go on.
The victim, the woman who allegedly survived that terrifying night, she wouldn't live long enough to testify. She passed away later.
Oh, wow.
Yeah, sadly, from circumstances completely unrelated to the alleged incident itself.
That's devastating. And legally, that throws a huge spanner in the works for the prosecution, doesn't it?
Totally. Her direct testimony, the core of their case, suddenly gone. The one person who could speak firsthand about those alleged hours was no longer available.
A huge challenge. How do you proceed when your key witness can't testify?
Well, and this is the absolute crux of the legal deep dive we're doing today. Her words, the accounts she gave right after the alleged ordeal. Maybe those words could still be heard by a jury.
Okay. So the question becomes, can the voice of a victim, silenced by this unrelated tragedy, still speak in court effectively?
That's exactly it. That's the monumental question. This isn't just recounting the alleged crime. It's about unpacking a specific legal fight that escalated all the way to the High Court of Australia.
Right. You're talking about Stephen Moore, a pseudonym v. the King. The High Court decision from August 14, 2024.
That's the one. Reported as 2024 HCA 30. And it really puts the spotlight on this tension, doesn't it? Between prosecuting serious alleged crimes and safeguarding the rights of the accused, especially when the key evidence comes from someone who can't be cross-examined.
Absolutely. It forces the courts to grapple with fundamental principles. How do you handle hearsay evidence in such tragic circumstances? What constitutes unfair prejudice?
So our mission today, using the court judgments, the legal submissions, all the related reports we could find, is to walk you through the human drama, the people involved, and this really high-stakes legal fight over whether her voice, effectively from beyond the grave, could be legally heard in court.
It's a powerful illustration, isn't it, how these deeply personal tragedies collide with the complex machinery of the law, testing its limits.
Let's start by properly introducing the individuals involved,
Yeah.
based on the court records.
Okay. So the person accused of these actions, the alleged perpetrator, is referred to throughout the proceedings using the pseudonym Stephen Moore.
Which is pretty standard practice, right, to protect identities, especially pre-conviction.
Exactly. It balances the public's right to know with individual privacy rights. Standard procedure in Victoria and many other places.
And the complainant, the woman whose home it was, the one allegedly subjected to this night of terror, it's crucial to understand that Moore's defense presented a totally different story, didn't they?
Oh, completely different. And that difference is the heart of the conflict the jury would need to decide. Stephen Moore admitted he was at her unit that night. That wasn't disputed.
But his reason for being there?
He claimed he was there with her permission. He said she let him in. And critically, his defense flatly denied any violence occurred. No assault, no threats, no holding her captive, no choking.
So his version was?
Simply that they had an argument. A verbal dispute, nothing more. And then he left. That's it.
Wow. So two diametrically opposed narratives. The prosecution alleging a brutal, prolonged attack and detention inside her home.
Right.
And the defense saying, yes, I was there, we argued, I left, no crime committed.
Precisely. The jury's job, if it went to trial with her testimony, would have been to decide which version was true beyond reasonable doubt, but without her testimony. Well, the prosecution needed another way to present their version.
And their version, based entirely on their allegations they intended to present, painted a very grim picture of that night.
It did. According to the prosecution case outlined in the judgments, Moore allegedly entered her home around 6 p.m. on August 30th, 2021.
And stayed until?
Allegedly until about 5 a.m. the next morning, August 31st. So roughly 11 hours.
11 hours. And during that time, the prosecution alleged a whole series of criminal acts occurred, leading to some very serious charges.
Extremely serious charges under the Victorian Crimes Act and common law. We're talking about allegedly, intentionally, or recklessly causing injury.
Okay.
Threatening to kill her or inflict serious injury.
Right.
Preventing her from leaving her own unit, that's false imprisonment.
And the choking allegation.
That formed the basis of a charge for recklessly engaging in conduct endangering life or serious injury. Specifically, the prosecution alleged he smothered her using his hands on her neck, mouth, and nose, causing her to actually lose consciousness.
Losing consciousness. I mean, the language used in the court documents reflecting the prosecution's framing is stark. They called it a night of terror.
They did. Phrases like choked to the broad of fatal harm were used. They framed it as her narrowly avoiding becoming another murder statistic. It underscores the alleged severity and why her account was so critical.
Okay, so the alleged incident ends around 5:00 a.m. on August 31st when Moore supposedly leaves. What happens in the immediate aftermath? How does her story start to emerge?
This is where we get the series of statements that became the focal point of the legal battle. She starts reaching out later that morning.
These are the previous representations the lawyers talk about.
Exactly. The first one, noted in the sources, happened about 6.5 hours after he allegedly left, sometime between 11:30 a.m. and 12:20 p.m. that day, August 31st.
Who did she contact?
She called her mother. Her mother is given the pseudonym Julie Dwyer in the court documents.
And what did she allegedly tell her mother during that call?
She made some very specific claims. She allegedly said Moore held her hostage all night, that he'd poured water over her repeatedly. Yeah. That he smashed a porcelain bowl and used a piece to slash her, and that he stabbed her wrist and threatened she'd bleed out in the bath.
That's incredibly graphic. And the mother confirmed this call happened.
Yes. Julie Dwyer provided a police statement supporting that the complainant made these specific allegations to her during that phone call. So that was the first documented account.
What was the next step? Did she call the police then?
Not immediately. First, the call to her mother. Then, around 12:50 p.m., she called 000.
The emergency number.
Mm-hmm.
And that call would have been recorded, presumably?
Yes. The representations she made during that 000 call were recorded, creating another piece of potential evidence.
Okay, so mother, then 000, then the police arrive.
Correct. Around 1:05 p.m., Senior Constable Stack arrived at her unit. The complainant spoke to him, made more representations about what happened.
And this was captured how?
On the officer's body-worn camera footage, so another recording. In these initial interactions with police, she identified Stephen Moore. She mentioned a knife and a plate being involved, and she alleged Moore had stopped her from leaving.
And she spoke to the police again after that.
Yes. Just a bit later, around 1:30 p.m., further representations to Senior Constable Stack also captured on the body-worn camera.
So multiple verbal accounts to police on camera.
And then later that afternoon, about 5:28 p.m., she gave a formal signed written statement to another officer, Senior Constable Rinderhagen. This statement, as you'd expect, provided much more detail about the whole alleged sequence of events and, again, specifically identified Stephen Moore.
Okay, let's recap that sequence. Over about, 12 hours after the alleged incident ended?
Roughly, yes.
She speaks to her mother, calls 000, speaks to one police officer twice, recorded on camera, and then gives a detailed signed statement to another officer.
A whole series of communication.
And it's these statements, 67 out of 70 initial representations were ultimately deemed admissible by the trial judge. In that pretrial, hearing these form the voice the prosecution desperately wanted the jury to hear, especially after her death.
Absolutely. The volume, the relative consistency across different people and formats, and the timing all happening within hours or that same day gave these statements significant potential weight for the prosecution.
Now, while all this is unfolding and Moore is in custody, awaiting trial on these initial, very serious charges, something else happens, an unexpected development.
Yes, this adds another layer entirely. We're talking about the attempted cover-up. This occurred in July 2022, so almost a year after the alleged attack.
And Moore is in custody at this point.
Yes, awaiting trial. And from jail, he writes a letter.
Not to his lawyer, though.
No, he addressed the letter directly to the complainant, the alleged victim.
What on earth did he say?
According to the court documents, the letter asked her to withdraw the charges she'd made against him.
Just asked her to drop it.
And more than that, he apparently offered to pay her money if she did.
Wow. Okay, that sounds like, well, like trying to buy his way out of trouble.
It certainly had the appearance of an attempt to interfere with the legal process, a serious one, but the letter never actually reached her.
How come?
It was intercepted by the prison authorities, as often happens with outgoing mail from inmates.
And that intercepted letter, what happened with it?
It became evidence of a new, separate crime allegedly committed by Moore while he was in custody,
Which was
attempting to pervert the course of justice, a very serious offense in itself.
I'll say. How did Moore respond when faced with this new charge? Did he deny writing the letter?
No, he eventually pleaded guilty to that charge, attempting to pervert the course of justice.
Right. So let's be really clear here. He admits, by pleading guilty, that he tried to improperly influence the legal proceedings by asking the complainant to withdraw the charges and offering her money.
Yes, that guilty plea is a formal admission to that specific criminal conduct related to the case itself.
But, and this is crucial for understanding the setup for the trial, how did that guilty plea sit alongside his position on the original charges from August 2021?
That's the key contrast. Despite pleading guilty to trying to make the charges go away, he absolutely maintained his innocence on the original charges.
The assault, the threats, the false imprisonment, the endangerment.
All of them. He pleaded not guilty to every single one of those charges stemming from the alleged incident itself.
So the legal position was effectively, I didn't do the things she accused me of back in August 21, but I did try to get her to drop the charges for those things nearly a year later.
That was essentially it, which meant the planned trial was fundamentally going to be his word, his denial against the prosecution's case. And the prosecution's case, due to the tragic event we mentioned, was now heavily reliant on those out-of-court statements made by the complainant.
And that tragic event, just to reiterate, was the complainant's death.
Yes. Before the trial on the main charges could actually start, the complainant passed away. And again, the courts were clear. Her death was from unrelated circumstances, occurring sometime after the alleged offending.
But her death completely changed the landscape of the trial, legally speaking.
Fundamentally, it meant she was no longer available to give evidence in person. She couldn't be called to the stand, she couldn't tell her story directly to the jury, and crucially, she couldn't be cross-examined by the defense.
Which brings us squarely back to that legal roadblock, hearsay. Can you break down again why her death made her statements hearsay and why that's usually a problem?
Okay, so the basic idea of the hearsay rule, right? It's about reliability and fairness. Generally, you can't prove a fact in court just by saying someone else told you it was true outside of court.
Like your example. You can't prove it rained by having your friend testify that I told them it rained.
Exactly. Your friend's testimony about what you said would be hearsay if used to prove it actually rained. The court wants to hear directly from the source, you, in that example, who can be questioned about it.
So in this case, the complainant's statements to her mom, to 000, to the police, about what Moore allegedly did, those were all made outside the courtroom.
Correct. They were previous representations, as the Evidence Act calls them, made out of court. And the prosecution wanted to use them to prove the truth of what she asserted in those statements, that Moore did assault her, threaten her, etc.
Which, under the general hearsay rule, Section 59 of the Evidence Act 2008 in Victoria, is normally not allowed.
Precisely. Section 59 says such evidence isn't admissible to prove the existence of a fact asserted in the statement. So, on the face of it, her statements were inadmissible hearsay.
And her death was the key to unlocking one.
Yes. The Evidence Act recognizes that sometimes hearsay evidence might be reliable or necessary, so it creates exceptions. Section 65 is a big one for criminal cases where the person who made the statement is now unavailable.
And unavailable includes being deceased.
Yes. Tragically, that's one of the definitions of unavailability in the Act. So, Section 65 potentially opened the door for the prosecution to use her statements because she had died.
But it's not automatic, right?
Yeah.
Section 65 has conditions.
Absolutely not automatic. Section 65, subsection 2, 65(2) lays out specific conditions. The prosecution had to show her statements met at least one of these conditions to get past the hearsay rule.
And which conditions did they rely on here?
They relied mainly on two possibilities under S665(2). First, paragraph B, that the statement was made shortly after the event it describes and in circumstances making it unlikely to be a fabrication, unlikely to be made up.
Okay, shortly after an unlikely fabrication. What was the second?
Second, paragraph C, that the statement was made in circumstances that make it highly probable that the representation was reliable, that it was trustworthy.
So the prosecution argued her statements fit one or both of those? Made soon after seemed unlikely to be invented? Or the circumstances just screamed reliability?
That was their argument, yes. They contended that the timing, the consistency, the nature of the communications all pointed towards meeting those requirements.
Okay, so that's the first hurdle. Getting over the hearsay rule, using the S65 exception because she was unavailable. But you mentioned a second massive hurdle, Section 137.
Yes, Section 137, this is a huge one. It's a mandatory exclusion rule. It acts as a final safeguard for the accused.
Mandatory meaning the judge has to apply it if the conditions are met.
Exactly. Section 137 says the court must refuse to admit prosecution evidence if its probative value is outweighed by the danger of unfair prejudice to the accused.
Probative value versus unfair prejudice. Let's break that down. Probative value is how much the evidence helps prove a fact in the case.
Essentially, yes. How relevant and persuasive is it to an issue the jury needs to decide? In this case, her statements identifying Moore and detailing the alleged acts clearly had high probative value for the prosecution's case.
Okay, and unfair prejudice. What does that mean in this context, especially when the witness is deceased?
The absolute core of the unfair prejudice argument here, and the point the defense hammered home, was the inability to cross-examine the complainant.
Because cross-examination is seen as fundamental.
It's considered fundamental to testing the evidence in our adversarial system. It's how the defense challenges a witness's honesty, accuracy, memory, perception, potential biases, everything. It's often called the greatest legal engine ever invented for the discovery of truth.
And without the complainant there to be questioned.
The defense argued that Moore was severely disadvantaged. Her statements, potentially forming the main evidence against him, would go before the jury completely untested by cross-examination. They argued this lack of testing created a profound and unfair prejudice against him.
I see. So even if her statements technically squeezed through the S65 hearsay exception, the judge still had to conduct this balancing act under S137.
That's right, a crucial balancing act. Does the value of this evidence in proving the case outweigh the unfairness to the accused caused by not being able to challenge it through cross-examination? That question became the absolute epicenter of the legal fight.
And this fight had to be resolved before the actual trial could even begin.
Yes, through a pretrial process, which takes us to the first formal battleground over these statements, the County Court of Victoria.
So before any jury is involved, the lawyers argue this admissibility point in front of just the judge.
Correct. This specific type of pretrial hearing is often called a voir dire, a sort of trial within a trial, purely focused on whether certain evidence should be admitted. Here, the focus was squarely on the complainant statements and application of S65 and S137.
Who were the legal teams arguing this in the county court?
For Stephen Moore, the accused, who later became the appellant, his defense team was led by the barrister Chris Carr SC. He was instructed by Angus Cameron lawyers.
And their main arguments on the voir dire?
They argued firstly that the statements perhaps didn't even meet the 65 requirements, maybe not made shortly after enough, or the circumstances didn't make fabrication unlikely or reliability highly probable. But their major thrust was on S137. Even if S65 applied, they argued the massive unfair prejudice from the lack of cross-examination must outweigh the probative value, demanding exclusion under S137. They stressed how vital cross-examination is a sine qua non, an indispensable condition for a fair trial.
Okay, a strong push on the prejudice argument. What about the prosecution, representing the king?
The prosecution team, lawyers from the Victorian Office of Public Prosecutions, the OPP, took the opposite stance, naturally. They argued the statements clearly met the 665 conditions, pointing to the timeliness, the detail, the multiple recipients as signs of reliability and unlikelihood of fabrication.
And on the S137 balance?
They argued the probative value was extremely high, direct accounts from the alleged victim identifying her attacker, someone she knew. They acknowledged the lack of cross-examination caused some prejudice, but contended the danger of unfair prejudice did not outweigh that high probative value. They suggested ways to manage the prejudice, like maybe the defense could still point out inconsistencies to the jury, or the judge could give specific instructions.
A really tough call for the county court trial judge. How did they rule?
The trial judge ruled almost entirely in favor of the prosecution. The judge found that 67 of the complainant's statements were admissible.
67? Wow. And on what basis?
The judge found the statements satisfied both key limbs of S65-2 that the prosecution relied on. So satisfied S65-2 shortly after, unlikely fabrication, and satisfied S65-2C, highly probable reliability.
Okay, so they cleared the S65 hurdle in the judge's view. What about the crucial S137 balancing act? Did the judge think the prejudice outweighed the value?
No. The trial judge specifically declined to exclude the evidence under S137. The judge concluded that the danger of unfair prejudice to Moore did not outweigh the significant probative value of the complainant's detailed accounts.
So the outcome was the jury would hear the complainant's story through these 67 statements, even though she couldn't be there to testify or be cross-examined.
That was the effect of the ruling. A massive win for the prosecution, allowing them to present the core of their case. But for the defense, this was a deeply concerning outcome, allowing potentially untested, highly damaging evidence to go before the jury.
They must have wanted to challenge that ruling immediately before the trial started.
Absolutely. And the trial judge recognized the immense significance of this ruling. The judge took a very important procedural step provided for under Victorian law, specifically Section 295 of the Criminal Procedure Act, 2009.
What did the judge do under that section?
The judge certified the ruling. Essentially, the judge formally acknowledged that this decision to admit the statements was so critical that if the judge was wrong about it, the error would likely eliminate or substantially weaken the prosecution case.
Why is getting that certification so important?
Because that certification is the specific legal key needed to unlock the possibility of an interlocutory appeal in Victoria on a point like this.
An interlocutory appeal meaning an appeal before the trial finishes.
Exactly. Normally you have to wait until the end of a trial, get a verdict, usually a conviction, and then you can appeal decisions made during the trial. But interlocutory appeals allow certain crucial pre-trial rulings, ones certified as potentially case determinative like this one, to be challenged immediately at a higher court.
What's the rationale for allowing that early appeal?
It's about efficiency and justice. If there's a potentially fatal legal error in a key pretrial ruling, it's better to get it corrected before everyone goes through a long, expensive, and potentially flawed trial, only to have it overturned later anyway. It prevents wasted trials and potential retrials.
Okay, so the judge's certification essentially said, this ruling is huge, potentially case-ending if I'm wrong, which gave Moore the green light to ask the next court up, the Court of Appeal, to review it right away.
Precisely. The fight over the admissibility of the complainant's voice moved up the judicial ladder.
So Stephen Moore, through his legal team, led again by Chris Carr SC and instructed by Angus Cameron lawyers, sought permission leave to appeal to the Supreme Court of Victoria, Court of Appeal.
That's the process. They needed the Court of Appeal's permission first. The respondent, the king, represented again by counsel from the Victorian OPP, argued against granting leave and defended the trial judge's decision.
What specific points or grounds of appeal did Moore raise before the Court of Appeal?
He sought leave on 4 grounds. 3 were technical arguments challenging the trial judge's findings under Section 65, basically saying the judge was wrong to find the statements met the hearsay exception criteria.
And the 4th ground?
The 4th ground was the big one, the Section 137 issue. Moore argued the trial judge erred in the balancing exercise and should have excluded the evidence because the danger of unfair prejudice from the lack of cross-examination did outweigh the probative value.
How did the Court of Appeal respond? Did they agree to hear all those points?
They granted leave to appeal on 2 of the 4 grounds. They agreed to hear the argument on 1 of the S65 points, and critically, they granted leave on the S137 ground. They refused leave on the other 2 S65 grounds.
Okay, so the appeal went ahead focusing on one aspect of the S65 exception and the overall S137 balance. What was the final decision of the Court of Appeal?
They ultimately dismissed Moore's appeal. They affirmed the trial judge's ruling on both points they considered.
So they agreed the statements were admissible?
Yes. They upheld the trial judge's finding that the statements met the requirements of Section 65-2B, made shortly after, unlikely fabrication. Because they upheld it on that basis, they said they didn't need to decide if the statements also met the S652C requirement regarding reliability.
And on the crucial S137 point, the balancing of prejudice versus probative value.
They also upheld the trial judge's decision not to exclude the evidence under Section 137. They agreed that the danger of unfair prejudice didn't outweigh the probative value.
So another loss for Moore's defense.
Yeah.
But you mentioned earlier that how the Court of Appeal reached its decision on a SEPA's 137 became contentious later on. What was the issue with their approach?
Yes, this is the point that really set up the High Court appeal. When the Court of Appeal reviewed the trial judge's S-137 decision, that balancing act, their judgment suggested they primarily applied the principles from a famous High Court case called House v. the King.
House v. the King. What does that case say about appeals?
The House principles basically set out how appellate courts should review decisions made by lower courts where the lower court judge had some kind of discretion, a range of acceptable choices. Under House, the appeal court doesn't just substitute its own opinion. It asks if the trial judge made an error of principle, took into account irrelevant matters, failed to consider relevant ones, or reached a decision that was plainly unreasonable or not well open to them. It involves a degree of deference.
So the Court of Appeal was essentially asking, was the trial judge's decision to admit the evidence under S-137 a permissible decision within their range of judgment, rather than was it the single correct decision?
That was certainly the interpretation Moore's team took of the Court of Appeal's primary reasoning. They felt the court was treating the S-137 Balancing Act as a discretionary judgment subject to this deferential House standard.
Did the Court of Appeal say anything else?
Well, interestingly, after applying that House approach, the Court of Appeal also added a comment, sort of saying, and just for completeness, we also think the trial judge was correct anyway. But the core issue for the defense was the standard the court seemed to be applying. Was it the deferential House standard or a correctness standard?
In this distinction, deference versus correctness for a crucial S-137 ruling on an interlocutory appeal, that's what Moore's team decided to take to the High Court.
Precisely. They fundamentally disagreed that House v. the King was the right standard here. They argued that balancing probative value against unfair prejudice under S-137 isn't a discretion in the House sense. It's a statutory requirement with, theoretically, one correct legal answer. And they argued that on an interlocutory appeal concerning such critical certified evidence, the appeal court's job is to find that correct answer, not just defer to the trial judge.
So the fight wasn't just about the evidence itself anymore, but about the very process of judicial review for these kinds of critical pretrial rulings.
Exactly. It became a question of fundamental legal principle regarding appellate procedure in criminal cases.
Which meant Stephen Moore sought special leave to appeal to the High Court of Australia, the final avenue.
That's right. And getting special leave isn't easy. The High Court only takes cases that raise significant legal questions, often where the law is uncertain or conflicting between states, or where it's a matter of broad public importance.
Did the High Court grant special leave in this case?
Yes, they did, in March 2024. And importantly, the High Court specifically granted leave only on the S-137 issue, and critically, on the question of what standard of review the Court of Appeal should have applied to the trial judge's S-137 decision on that interlocutory appeal.
So the High Court signaled, yes, we need to clarify the law on how appeal courts should handle these specific S-137 interlocutory appeals.
Precisely. The focus narrowed right down to that procedural but fundamentally important point.
Who were the justices on the High Court bench that heard this appeal?
The appeal was heard by 5 justices on June 5, 2024. It was Chief Justice Gagler, Justice Edelman, Justice Stewart, Justice Gleeson, and Justice Beach Jones.
A full bench for a significant point of law, and the legal teams arguing before them. Same counsel as in the Court of Appeal.
Largely, yes. For the appellant, Stephen Moore, the team was again led by Chris Carr SC, but now joined by J.R. Murphy and P.D. Coleridge as barristers, still instructed by Angus Cameron lawyers.
And for the respondent, the King.
The prosecution team was led by B.F. Kissane KC, note the title change to King's Counsel, and also included J.P. O'Connor, instructed by the Victorian OPP. So continuity in the lead counsel, who were intimately familiar with the arguments.
Okay, let's dive into those arguments before the High Court. What was the absolute core of the case put forward by Moore's team, led by Carr SC?
Their number one argument, the reason they got special leave, was all about that standard of review. They argued forcefully that the Court of Appeal messed up by applying the deferential House v. the King standard to the S-137 ruling.
Their point being, S-137 isn't discretionary.
Exactly. They insisted S-137 requires an objective balancing exercise mandated by statute, and that exercise has one legally correct answer. It's not about a judge having a range of acceptable choices. It's about getting the balance right according to law.
So they argued the Court of Appeal should have essentially redone the balancing exercise from scratch.
Yes, de novo, starting afresh. They argued that on an interlocutory appeal of such a crucial certified ruling, the appellate court must apply this correctness standard. They need to make their own independent judgment on whether prejudice outweighs probative value without giving special weight to the trial judge's view. They linked this to the purpose of interlocutory appeals in Victoria to fix critical errors early and avoid flawed trials. Applying House, they said, undermines that purpose.
It forces the accused to go through a whole trial just to properly challenge the ruling later, or worse, maybe plead guilty based on a wrong ruling.
That was their contention, yes. A very strong argument about procedural fairness and the efficiency of the system.
So that was the standard of review argument. What was their second main line of attack? Assuming the correctness standard applied, did they argue the evidence should have been excluded?
Yes, absolutely. They argued that if the High Court agreed the standard was correctness, then applying that standard correctly to the facts here would lead to the exclusion of the complainant's statements. They argued the Court of Appeal, even in its alternative reasoning, had seriously underestimated the danger of unfair prejudice.
How do they articulate that prejudice?
They kept coming back to the loss of cross-examination, calling it a real and unfair prejudice, denying Moore the use of that greatest legal engine for truth testing. They weren't just saying it was generally unfair. They pointed to specific, plausible lines of cross-examination that were now impossible.
And these went to the heart of the complainant's credibility and reliability.
They argued yes, particularly on the crucial issue of identity, or at least the description of the perpetrator's relationship to her.
What was the specific inconsistency they highlighted again?
The main one was her alleged reference to the perpetrator as her ex-partner in the 000 call, and also later to the forensic medical officer. The defense stressed she was not in a relationship with Stephen Moore. She'd recently ended one with someone else. They argued this inconsistency was significant, unexplained, and could cast doubt on her overall account or identification, but without cross-examination, the jury was left completely guessing, was it a mistake, a lie? How much did it matter? They couldn't ask her.
That does seem like a concrete point that cross-examination is designed to explore. What other areas did they say were lost?
They pointed to several other things. That 6.5-hour gap before the first detailed complaint, her alleged history of excessive drinking and medication use, which might affect memory or perception, her apparently calm demeanor on the body cam footage, which they argued contrasted with the horrific allegations, and even affectionate letters she apparently wrote to Moore later while he was in custody, which they couldn't ask her about to probe their relationship and potential motivations.
So a whole suite of issues typically tested in cross-examination.
Exactly. They argued the cumulative effect of being unable to test any of these points created an overwhelming unfair prejudice. They also argued the sheer volume 67 statements risk an illusory truth effect, making the story seem true just through repetition. And critically, they contended that standard jury directions couldn't fix this specific prejudice, the inability to test credibility and reconcile unexplained inconsistencies.
Okay, a powerful case from the appellant. How did the prosecution, the King's team, led by Kissane KC, respond to these arguments in the High Court?
On the standard of review, the Crown, representing the King, sort of defended the Court of Appeal's approach, arguing the legislation didn't explicitly state the standard, so applying House was at least open to them, consistent with appellate restraint. But they quickly pivoted.
To what?
To arguing that even if the High Court decided the standard was correctness, the trial judge's decision to admit the evidence was correct anyway. So they tried to cover both bases.
Defend the method, but insist the outcome was right regardless.
Pretty much. They really focused on arguing that the S-137 balance was correctly struck in favor of admission.
How did they counter the defense's detailed arguments about prejudice, like the ex-partner, inconsistency, and the lack of cross-examination?
They started by emphasizing the high probative value of the statements. Direct accounts identifying Moore, whom she knew well, made relatively soon after the alleged events. They argued mistaken identity wasn't a plausible issue regarding who she was accusing. The circumstances, they argued, pointed strongly towards reliability. Then, on prejudice, they conceded, yes, lack of cross-examination is a form of prejudice, but they characterized it as moderate in this context and argued it did not outweigh the high probative value. Their key argument was that the defense wasn't left completely helpless.
What did they mean? What could the defense still do?
They argued the defense could still bring out facts relevant to the complainant's credibility or reliability through other means. For example, they could cross-examine the mother about the phone call, cross-examine the police about the complainant's demeanor, potentially introduce the letters, or other evidence related to her background if relevant and admissible.
But that still doesn't let them ask the complainant herself to explain the inconsistencies.
True, but the Crown argued that once the defense had put these potentially challenging facts before the jury via other witnesses or evidence, they could then make strong submissions in their closing address. They could highlight all the inconsistencies, point out the gaps, emphasize their forensic disadvantage because they couldn't cross-examine her, and invite the jury to place less weight on her statements as a result.
And they relied heavily on jury directions, too.
Oh, absolutely. This was central to their argument. They insisted that the trial judge could and would give appropriate and strong jury directions to mitigate the prejudice. They specifically mentioned directions under the Victorian Jury Directions Act about forensic disadvantage and the potential unreliability of evidence where testing is limited.
Their position being that juries follow directions.
Yes, they leaned on the fundamental legal assumption that juries listen to, understand, and follow the judge's instructions on how to approach the evidence. They argued that any risk from the volume of statements or the lack of cross-examination could be effectively managed by careful directions.
So the Crown's position: high-value evidence, manageable prejudice through other means, defense submissions, and robust jury directions. Balance favors admission.
That captures it well. It set the stage for the High Court's decision.
And that decision came down on August 14th, 2024. A unanimous judgment. What was the final result for Stephen Moore's appeal?
The High Court unanimously dismissed his appeal.
Dismissed. So ultimately, the decision to admit the complainant's statements stands.
That's right. The outcome reached by the trial judge and the Court of Appeal was upheld. The statements are admissible.
But crucially, even though the result was the same for Moore, the High Court's reasoning clarified the law significantly, didn't it?
Immensely significant clarification, yes. Even in dismissing the appeal, the unanimous judgment laid down some key principles that will definitely impact legal practice, particularly in Victoria and other places with similar evidence laws.
What was the first major finding? The one about the standard of review.
On that critical point, the High Court agreed with Stephen Moore. They ruled definitively that when an appeal court is reviewing a trial judge's S-137 decision on an interlocutory appeal certified as critical, the appeal court must apply the correctness standard.
So no more House v. the King deference for these specific rulings.
Exactly. They explicitly rejected the applicability of House principles here. They said a S-137 balancing act isn't discretionary in that sense. It requires finding the legally correct outcome. The appeal court has to conduct the balancing exercise afresh, de novo, and make its own determination. They found this approach consistent with the purpose of the Victorian interlocutory appeal scheme.
That's a huge clarification for appellate practice. It gives appeal courts a much stronger mandate to intervene pre-trial if they think a trial judge got the S-137 balance wrong.
It absolutely does. It sets a higher bar for review.
But despite agreeing with Moore on how the review should be done, they still dismissed his appeal. How did they explain that?
Well, that leads to their second key finding. Having established that correctness was the standard, the High Court then proceeded to apply that standard itself to the specific facts of Moore's case. They did the de novo balancing exercise.
They stepped into the Court of Appeal's shoes, essentially.
Exactly. They asked, applying the correctness standard, was the trial judge's decision to admit the evidence the right one? And their unanimous conclusion was, yes, it was correct. They found the danger of unfair prejudice did not outweigh the high probative value.
So they effectively said, the Court of Appeal used the wrong method.
Yeah.
House. But even using the right method, correctness, we reached the same conclusion as the trial judge and the Court of Appeal did on the outcome.
That's precisely the effect. They acknowledged the prejudice from the inability to cross-examine. That wasn't disputed. But crucially, they stated they found no basis for concluding that this inability would substantially affect the jury's capacity to rationally assess the weight of the statements.
Why did they think the jury could still rationally assess it, despite the points the defense raised?
Their reasoning mirrored the Crown's arguments to some extent. They felt that the defense could still bring out matters relevant to credibility, the alleged inconsistencies, the demeanor, the timing, the background issues, through other evidence presented at trial. And, like the Crown, they placed significant weight on the power of jury directions. They believed that appropriate strong directions from the judge, specifically addressing the forensic disadvantage and the potential unreliability of untested evidence under the Jury Directions Act, would be sufficient to mitigate the risk of unfair prejudice. They relied on the principle that juries are presumed to follow directions.
So the High Court's view seems to be, yes, losing cross-examination hurts the defense, but it doesn't automatically make the trial unfair. provided the defense can still air the challenging point somehow, and the judge gives very clear warnings to the jury about the limitations of the evidence.
That seems to be the core of their reasoning on the balance. The prejudice, while real, was deemed manageable through those other mechanisms and thus didn't outweigh the high probative value of the victim's account. Therefore, the appeal was dismissed.
Okay, let's talk impact. What does this High Court decision in Stephen Moore v. the King actually mean for Australian law and practice going forward?
Well, the biggest legacy is undoubtedly the clarification on the standard of review for S-137 interlocutory appeals. It's now settled law in Victoria, and highly persuasive elsewhere with similar laws, that appeal courts must apply the correctness standard, not house deference, when reviewing these critical pretrial evidence rulings.
And that change, does it strengthen protections for the accused?
You could argue it does. It means a potentially incorrect decision by a trial judge to admit highly prejudicial evidence is now subject to a more rigorous, non-deferential review before the trial even starts. The appeal court has to be actively satisfied the balance was struck correctly, not just that the trial judge's decision was open to them. It provides an earlier, more robust check.
Could we see more defense teams trying to appeal these NGL 1137 rulings free trial now?
It's certainly possible. Knowing the appeal court has to conduct a full de novo review might embolden defense teams to challenge admissibility rulings on interlocutory appeal more often, testing the limits of unfair prejudice under this clarified standard. It gives them a clearer path to argue the appeal court should substitute its own view. It also reinforces a broader point about judicial decision-making, doesn't it? That even complex balancing acts like PROSA 137 aren't just matters of gut feeling or broad discretion, but involve legal principles that lead to a correct answer susceptible to proper appellate scrutiny.
And let's bring it back to the people involved. For Stephen Moore's trial, what's the immediate practical consequence of this High Court ruling?
The practical upshot is clear. Those 67 statements made by the complainant, her detailed accounts of that alleged night of terror, are admissible evidence. The prosecution can present them to the jury.
So, tragically, although she passed away and cannot testify in person, her voice, captured in those statements made shortly after the alleged events, will be heard in court.
That is the direct legal result of this entire legal battle.
Right.
Her previous representations can be used as evidence of the facts she asserted.
What a journey this case represents. From those initial terrifying allegations inside a suburban home, through the complainant's tragic, unrelated death, the accused's attempt to interfere with the case from custody, and then this incredibly complex, multi-layered legal fight climbing all the way to the High Court, all centered on whether her words could be admitted.
It really does touch on so many challenging aspects of the criminal justice system. The High Court provided crucial clarity on the standard for reviewing these evidence decisions pre-trial, demanding correctness. But in applying that standard here, they ultimately concluded that the decision to let the jury hear the complainant's account, despite the lack of cross-examination, was the legally correct one.
It really highlights that constant, difficult balancing act the system has to perform, doesn't it?
Absolutely. You've got, on one hand, the fundamental rights of the accused, the right to a fair trial, the right to test the evidence against you, primarily through cross-examination. That's sacrosanct.
And on the other hand,
you have the need for justice, the need to ensure that relevant, highly probative evidence, especially from alleged victims detailing serious crimes, can actually be considered by the court even when tragedy prevents them from testifying in the traditional way.
So thinking about that balance, what does this outcome in Stephen Moore v. the King suggest about where Australian law draws the line today?
Well, it seems to suggest that while the absence of cross-examination is acknowledged as a significant disadvantage, a serious prejudice, it's not necessarily seen as an insurmountable bar to admissibility, especially for highly probative hearsay evidence from an unavailable witness that meets the 665 criteria. The High Court's faith in the ability of other mechanisms, alternative ways to challenge credibility, defense submissions, and particularly strong judicial directions to mitigate that prejudice seems quite high. It suggests a view that a jury, properly guided, can rationally assess untested evidence. It's a complex equilibrium, and this case offers a very clear statement from the highest court on how that balance is struck in these specific, difficult circumstances.
A profoundly important case with lasting implications. Thanks for breaking that all down for us.